I'm gonna pop up a quick PowerPoint to go with the comments. I'm gonna try to go through this pretty quickly so I can take whatever questions people have, because those tend to get to the issues that are really most interesting to the individual participants. So the topic tonight was protecting your work in the digital age. What do you need to do to ensure that your work is protected from copyright infringement? And before jumping in, and I'm sure everybody on this chat right now is aware that copyright infringement is an endemic problem that is really growing and not shrinking. The ease with which people can steal your work, the internet being a global phenomenon. We were talking earlier tonight, you'll find your pictures being infringed in some of the most exotic locations, and you can't imagine how do they find it, how do they get it, and what are they doing with it, and what can I do about it? So first, let's see. A little introduction to myself. I'm the founding partner of the Sanders Law Group. We're an intellectual property firm based in New York. There were 12 associates plus myself. I graduated from the University of Pennsylvania in 1993. And as you can see from the admission list, I get around a little bit. Why is that important? Well, it's important because when it comes to the enforcement side of things, the selection of where that lawsuit, if it is a lawsuit, would take place is based on the defendant, not based upon the plaintiff. So we can only sue people where they have their principal place of business or they reside, which means we have to go to them. And my firm covers just about all of the population of the US. Donna had a quip that I used, where there are more people than cows. So, the odds are that if your work is infringed, we have a physical ability without having to go out to local counsel to file it in our own firm. I personally have handled an ungodly number of cases for clients over the years, and have had the opportunity to argue copyright cases throughout the federal court system, all the way up to the Supreme Court. So the best practices for protecting your work. We're going to run through each of these quickly. The first, understand who owns the work and what right that entitles you to. This comes up in work for hire situations, and just a general understanding of what copyright is. So copyright is the right to intellectual property. That sounds simple. It's a property right. It kind of works the same as real property rights, like a home. It is the only right that appears in the main body of the US Constitution. All the other rights that we've been granted come in the Bill of Rights. Copyright was the only thing that the founding fathers put into the original document, which is an interesting bar tip. The rights that you are afforded under copyright appear in 17 U.S.C. 106. And this is the list right here: to reproduce, to create derivative works, to distribute, those being the key rights involving photography. Now, who owns the work? This comes up with work for hire situations. Work for hire is covered also in 17 U.S.C. This is under section 101. It's pretty simple when it's an employee relationship. Anything you do on behalf of your employer owns the rights to that work. There's no rights assignment. The rights never vest in the employee at all. Where it comes up additionally is when somebody asks you, or specifically hires you, to take or create a work. Now, this is going to be mostly the latter bullet point, when there's an express written agreement signed by both parties saying this will be a work for hire. So if somebody orally asks you to go out and photograph something and you're not their employee, That is not work for hire. You own the rights to that image. If that same arrangement was done with a writing and the words work for hire appear in that writing, then whoever hired you would own the rights to that image that you create. The next issue that comes up quite frequently is accidentally giving something away. And this happens a lot on social media these days. I'll touch on that briefly, but best practices to avoid that happening. Make sure that your licensing information appears on your website if you have one. Make sure that if you post anything on social media, you make it clear that you are reserving all the rights to the image, and that anybody who wants to use that image for commercial purposes should contact you for licensing. These are simple ideas, but very, very, very important. Now, if you post something on Twitter, Instagram, Snapchat, any of these services, you are subject to their terms and conditions. And those terms and conditions provide that you have granted that platform, Twitter in this example, the right to use that image on their platform in any way, any manner, by anyone, as long as it stays on the platform. It's as broad a grant as you can come up with. As long as it's on the platform, it's fair game. Now, that is an interesting side note. If somebody were to download your image from the platform and then re-upload, breaking the link, that would still constitute an infringement. Sharing within the service, no matter how they share, where they share, or what they share with, that would not be an infringement. But what you want to make it clear is that merely the fact that you put it up on social media didn't mean that you wanted to give it away to anyone. You were keeping the commercial rights, and really those are the rights that everybody should be concerned about. You know, for once to appear on, a small family group chat, that's not really something that you would take action on anyhow. But if somebody wants to use it as their banner page for their website, you should get paid for that. So you want to make it clear that you've reserved the rights to all the commercial licensing, and it's really simple to do. Just put something on your page that says that. Contact information, how to get in touch, simple but a best practice. The other thing that you want to do is, to the extent that you do have a licensing agreement, you want to make sure that you describe in that licensing agreement what you're granting and to whom and for what purpose and for how long. That's the key language in this agreement. The rest of the agreement is almost nonsensical. The grant is the paragraph that you should be paying attention to. What have you given permission for someone to do, and for how long and where? What rights have you reserved? Do you want to make sure that it's not used for some period purpose? You need to make sure you include that in the agreement. You could also do this on your invoice. If you just use invoices, you could put a reference to your own website where you have posted terms and conditions. Whatever gets the message across that you haven't granted them everything. That's what you want to focus on. That's what you want to do. And you can convey it in so many different ways. Again, it's important that you recognize that the grant is the key language in this situation. And you want to make sure that you've limited that to what you've been paid for and not to everything that somebody might want to use it for. The next thing you need to do, and this is as important as it gets, this is the keys to the kingdom. You have to register your work. And you have to ideally register your work timely with the U.S. Copyright Office. Now, timely means, just to break away from the slide for a second, that you're registering it within 90 days of its date of first publication. If you do that, then nobody could infringe upon it before you've registered it, because the Copyright Act provides that the date of registration would be the date of first publication. So if you do 4 quarterly registrations, you'd be covered for all of your images to the extent that you could fit them into the 750 group registration maximum. And if you don't timely register, you're giving up a whole host of benefits that you'd be entitled to, which are called enhanced copyright damages. Those are the rights to statutory damages instead of actual damages, and attorney fees. And those are the hammers that get you the better settlements, the better outcomes, and that's what people are afraid of. They're afraid of being sued and having to pay both their lawyer and your lawyer. And they're afraid of those big numbers that you get for a statutory award. So timely registration, very, very important. How do you register your works? Well, the easiest way to do it is create an account with the U.S. Copyright Office. An even easier way to do it is to work with us, because we'll do this for you. You create the account. You have to organize your work. As anyone who's ever done this, you have to be very anal about this. You need to organize your deposit copy. You need to name your files. You need to have everything in the right resolutions, so that you don't hit over the megabyte cap. And you need to create an Excel file. It's a little bit of a pain in the butt. And this is what I've touched on already. You get really a big difference between actual and statutory damages. So actual damages are the lost licensing fee if the image has a licensing fee, or the disgorgement of any profits earned by the infringer. Now, if this image becomes part of a product, actual damages could be quite large. We had a case, a textile case. We were suing a big box retailer, and we were claiming the disgorgement of all the money that they made for the sale of that infringing item. Much bigger than the statutory damage award. On the other hand, when you get involved with photography, oftentimes the images have limited licensing history, and we will be hard pressed to prove how much profit they made from an individual web page. So statutory damage is the preferred route. Statutory damages under the U.S. Copyright Act are between $750 at a minimum and $30,000 at a maximum for a non-willful infringement. If it's a willful infringement, the statutory maximum cap is $150,000, and this is per work that was infringed upon. Now, that doesn't mean that if you have a single photograph that is infringed, that you're going to get a check in the mail for $150,000. But it does mean that that is the maximum that you would be entitled to, should the circumstances provide that that's what you should get. The courts in fashioning these awards try to do a couple of different purposes. One is they try to make sure the photographer gets paid, and they also want to do a punitive effect. They want to punish the infringer somewhat for having stolen the image in the first place. They recognize that if all they did was make the infringer pay the licensing fee, there'd be no incentive not to infringe, because they only get caught a percentage of the time. And if they only had to pay the licensing fee on a percentage of what they steal, then there would be a very big advantage to stealing. And the focus of the Copyright Act throughout the code is to basically foster innovation, design, and creativity. And that necessitates giving benefits to creations and creators, which means that they have as a purpose of this act to punish people who steal. But you have to set yourself up in a position to get that benefit. You have to register your work. If you don't register the work, you can't go to court, because registration is a prerequisite to filing a case in the federal court system. And if you don't register timely, you're giving up all those enhanced benefits. The next thing you need to do is keep track of who's stealing from you. And that involves monitoring your work for possible copyright infringements. Now, Google provides a reverse search mechanism. Probably most of the people here have used it on more than one occasion. You load your image, it shows you potentially infringing images. It's an imperfect tool that gets better all the time. Sometimes if there's text that's been written over your image, Google doesn't find it all the time, but their algorithm does get better and better over the course of time. The problem with this tool is it's one image at a time. So if you've got 20, 30,000 images, you'd never get through them once, little less recycling through them on a regular basis. We use a proprietary software that allows us to take all the images for our clients and cycle through them constantly. It takes us about a month to get through front to back the 1 million+ images that we're currently monitoring for our clients. And then we get all the infringements or potential infringements documented. We save all the screen grabs, we create all the documentation, and then we start the process of figuring out who just stole from you. I mean, it's a process now. Researching infringer information and figuring out who's behind that website has become more difficult. And I throw this up as an example. This was a real life case. We had a client image. It appears on the Stephen Dale Pet World website. If you went through this website front to back, you couldn't find the corporate identity of Stephen Dale Pet. If you go to Whois, which is a domain tool that allows you to look up the information associated with a website, you're going to find that 95% of the websites today have domains by proxy or private registration information where you can identify through that tool who owns the website. You would have to go through legal mechanisms in contacting, in this case, Contact Privacy Inc., and follow their protocols in order to get the information of who owns that website. But we have a team of research analysts, and this is all they do all day long. And they work this way backwards. They went into the LinkedIn content. They found out the identifier for Stephen Dale's Pet World. They go into open corporates. They found out this information, where this business was registered. And lo and behold, we now have a documented infringement. And we're able to provide that to our client and say, did you license it to these folks? Because if you did, it's not an infringement. And we shouldn't be pursuing it or doing anything. But if you didn't, do you want us to contact them and see if they're willing to pay for their image, or at the very least take it down? This was a pretty easy one because this website provided a pretty easy link. But we as a group of attorneys and our research assistants are constantly battling to figure out who's behind the curtain, because it is becoming increasingly difficult to connect websites to people and websites to businesses. And then this is where the next option. So you found the infringement, you registered your work, you did everything you were supposed to, you sent them a letter, and you get dead air. Maybe they take it down, maybe they don't take it down. Maybe taking it down was all that you needed but doesn't make you whole. They used your work. If it was a news photography image, they sucked the value out of it. The news cycle's over on that image. They'd be happy to take it down. Or maybe it wasn't getting that many hits and they just don't care. But either way, you're not made whole because they used your work for a period of time without paying for it. This is where we come in. Now, our office works on a contingency model. So you don't pay us anything. We only get paid if we're able to generate a recovery for you. And we have a model where we reach out to these folks in advance of doing anything and say, have you got a license for the use of that image? We call that a license audit. We get a response, we forward the response, we work with the clients, we discuss, how would you like us to pursue this? What are you looking for in terms of value? Oftentimes we get, I don't know, do the best we can, and that's what we do. We do the best that we can. If we can't get a response, we reach back out to the client and say, would you like us to file this case? If that's the answer is yes, we'll generate a summons of complaint and we'll file that in federal court. We will advance all the costs associated with the litigation. We'll get it served and we'll take it from there. We'll see what happens, what the interest level is in settlement. I would say that For every 100 cases we file, about 80% of the time, the first contact with our office is early resolution. Sadly, the other 20 is dead air again, and we're getting a judgment, and then we have to worry about judgment collection. But more people, once it gets to the point where a lawyer is involved, want to settle these cases than allow them to get ahead of steam and proceed forward. We also, if you work with us, we take a lot of the headache out of everything I just said to you. If you upload your images to us through our FTP site, we organize them and register them for you. If we are finding on a regular basis infringements, we will absorb the cost and we'll charge it against any of the files that are created. So there's actually no cost for our registration service. If we're not finding any infringements, we charge, I think, just a slight markup. I think we get $20 over the actual cost of filing it with the Copyright Office, which, to be frank with you, doesn't even cover the labor involved to anybody who's ever registered the images. But they're in our system, and we'll track them from that point forward, and we'll continue to monitor them and look for infringements. It is a headache-free approach to ensuring that people don't steal from you. We're not the only firm. I think we're probably significantly larger than anybody else out there. There aren't a lot of firms out there considering the level of infringement, but it's something you guys should very much consider because, I've used the word steal a lot because that's what's going on. Somebody who right-clicks, downloads, saves, and uploads for a commercial purpose did so to save a licensing fee. The licensing fee is your money. That's what you're entitled to for having created that image. And we're here to help with that. That's our job. That's what we do all day long, every day. And we're kind of interested in it because copyright is really at the forefront of everything. We were listening earlier tonight at a conversation about AI. Copyright's right in the middle of that. So it's an exciting space. We're happy that we're here, and we're happy with our clients. We're happy that we, in our opinion, do good, because that's what we look at here as our mission statement. So that was a brief overview. I kind of cruised through it. We have a small group here tonight, so I figured it'd be easier to just address any specific questions anyone has. If we don't get to a question for whatever reason, I'm happy to have you guys email us, and we'll take them one at a time, and we'll get your responses.
Thanks, Greg. That was great. We actually have a few questions in the chat, and I will pose them to you. So one of our members would like a little more clarification on copyright issues involved in posting your image on social media. It sounded like you said that someone else can grab your image off of social media and use it within their own social media, but they can't take it on that same platform, but they can't take it off of that platform. Is that what you were saying?
All right, so you've granted, when you post to a social media site, a license to that social media company. And it's an all-encompassing license. But that social media company only has an interest in content staying on their platform. That's their goal. They want to drive traffic so they can get ad revenue. So if somebody takes the image off the platform, that is not within the terms of services. It's not within the grant that you've given to Twitter, for example. So we give an example. Somebody posts to social media. We use Twitter just for simplicity's sake. And that image is shared using Twitter's system for sharing it. That is not an infringement. That is an authorized use. It could be shared downstream thousands and thousands of times. All would be authorized. Somebody then, instead of using Twitter's feature to share it, downloads the image to their own computer or their phone and then re-uploads it. And so instead of carrying forward your original post so that it all stays connected, the chain is broken. That is not an authorized act under Twitter. And that would be an infringing act by whoever did that. Now, one of the things that does come up is that a lot of times you'll see images get embedded from Twitter into a website. And embedded images, hyperlinked images, is a bunch of different ways, inline linking. Depending on where you are, it may or may not be something that constitutes an infringement. In the Ninth Circuit in California, it's not. There was a case in 2007. It hasn't really been challenged, although we have a case coming up right now that might. They employed what's called the server test. And that's been the law in the Ninth Circuit, which covers basically the whole west side of the country, which looks and asks a simple question of where is the image that is being displayed located? If where it's being displayed from is a licensed use, then it's not a copyright violation, it's not even a copy. There's been some breakaway districts because they've recognized that that test allows for a lot of misconduct. And we have a groundswell of cases that we've been responsible for in the Southern District of New York that have looked away from the server test. And that has been expanded. We've had cases now in districts throughout Texas. And we're seeing this as a growing trend. So we're not sure where that's going to eventually end up. But right now, whether or not an embedded image in a website from a social media site is actionable or not is up in the air. Depends where you are.
Mark, I'm going to unmute you. And Mark asked that question originally and has some follow-up questions. So I'm going to just get him to ask them.
Okay. Hey, Craig. I guess the other part of the question is that, say you put it up on Facebook, you put your image up on Facebook, and I understand that you can, someone else can reuse it within the context of the social media platform. My question, the second part of the question is, what can Facebook do with the image? Are they essentially, you're giving them this right, and they in essence can compile an image bank and then use those images commercially?
They could use them on Facebook for whatever they want. You're right.
But
your rights grant is to stay on Facebook. So Facebook, within Facebook, if they wanted to and they suddenly had a new business model, they would be able to do with them on Facebook whatever they wanted. Your question, I guess, presupposes, what if Facebook wanted to start a photo agency and start selling these things to third parties?
Right. Licensing them, yeah.
It's not going to happen. But if it did, there'd be a mass exodus from Facebook because people don't want Annie's picture being sold.
I mean, you're saying it's not going to happen sort of as a prediction because of, like you said, what it might do. But is in reality, have we given them the right to be able to do that if they want to?
I'd have to check the actual wording of the terms and conditions for the grant. I know it's to Facebook. I'm not sure if they also included for use on Facebook.com or the platform or some other, language that limits it beyond. I know that you've granted to Facebook the entity, a license. Right. Whether or not they've self-limited that license in the rest of the terms and conditions, I'd have to look because I don't want to guess on that point.
I mean, because that has always been my sort of that's always been sort of my concern and fear, and why I've pretty much stayed off of social media because of that. That I've read it. I'm not a lawyer. I probably read it now years ago, and it just seemed to be, in some sense ambiguous to the point where I couldn't make out if they could do it or not.
No, it's a pretty broad grant. That's why I'd have to check it. The issue you're describing hasn't come up yet, so it hasn't been the focus of anything that we've had to work on. And like all lawyers, I'm hesitant to guess.
Sure.
I'm happy to take a look at it and give you an opinion after I have a chance to actually read the wording. I mean, it's a contract. These terms and conditions
Right.
on their website,
Exactly.
they're adhesion contracts. So basically, it's the same as a lot of different contracts. If you agree to use it, you agree to be bound by the terms of it. I have to just take a look. It's simple enough to, see what the language is. It's going to be different though. And the other thing to keep in mind is that, like all adhesion contracts, the terms and conditions can be changed by the sponsor anytime they want.
Right.
So if
Right.
they change their position on this issue, they could just change it. Then you have, the ability to take your content down, which would end that grant. But I'd have,
Well,
like I said,
right. If they change it and all of a sudden you say, I'm going to take it down, but they still have it because you've been on it for 15 years and they've sort of collected all these images. I mean, they could be the largest photo agency in the world.
perhaps. I mean, like I said, I think it's anathema to the business model, because that's just not what they want. They want users, they want user traffic, because they
Sure.
make money selling ads. And so anything that would reduce user traffic would not be in their best interest. But you raise a valid point. If they were to go rogue, what would it look like? I'd have to actually check on the other issue, because it's always been my understanding that if you take your images down, they're not entitled to keep an archive or continue to use them.
Okay. Yeah. I mean, I agree with you. I mean, in this sense, right now, it wouldn't make sense for them to do that. But, 5 years from now, Facebook might not be the Facebook we see right now, and they could be where Kodak was in terms of going out of business or looking for some other way to recapture, money. And one of those options might be licensing images.
No, it's a good point. I mean, we could look and take a look for you and see what it says today. Future predictions are
No, yeah. Well, I understand. Yes.
but they're still a very large company. I mean, and they'd have to be replaced. I mean, Kodak was replaced by
Polaroid was replaced. Polaroid was replaced. Right. Polaroid was replaced, and Sears was replaced by Amazon. So, I mean, I look at these things and say, well, sure, there's all this stuff going on right now that makes somebody the 800-pound gorilla in the room, but that doesn't mean they're always going to be, and that they're not going to look at ways to recoup or regenerate money.
No, agreed.
Greg, can I
Just go ahead.
No, I'm sorry, continue. I was gonna ask if I could follow up on the follow-up and parse this question a little finer even. And if we go back to that example you showed earlier about the sort of pet store that misuse an image on their website. Well, what if the situation was that same pet store grabbed my image from my Facebook page and used it as their banner image on their Facebook business page? Clearly it's advertising. Are they okay in that situation?
So there's two ways they could do that. One, they could copy the image, which would make more sense because it's their banner page, right? So they don't want a link that could get broken. The second somebody makes a copy, regardless of whether or not it came from social media or somewhere else, they've infringed. So that's a copyright.
Even if that image stays on that platform.
Well, if they wanted to use as their banner image a link to Facebook. So that would be our embedded image or hyperlinking example that we were just talking about. My next question to you would be, where are they located? And I could tell you, based upon where they're located, what that court system's current viewpoint is as far as whether or not an embed is an infringement or non-actionable. If they were in California, right now the answer is easy. It's not an infringement. If they're in New York, the answer is equally easy. It is an infringement. So it depends on where they're located.
Okay.
So the technological way they do it is part one, and where they're located comes up as a part two question, depending on how they chose to infringe.
So we have another question from one of our members who would like you to speak to the cost of registration, and particularly the fact that there's no longer an unlimited option for registering pictures, and whether you think that's the cost is a deterrent or if it's adequate, fair. What would you say?
Right, so group registration is limited at the moment at 750 photographs. I don't know if that limit will stay in place, but it's been there for a little while now. That's a $55 registration. It's a heck of a lot better than the alternatives, which aren't available for videographers, where they have to go by one still. So the cheapest registration is a group registration for photography. The advantage is that every image in that registration is deemed individually registered. And what I mean by that is, if you have 750 photographs in a group registration and somebody infringes on all 750, then you would have 750 statutory damage awards coming your way. You could register a far larger number of photographs through database methods by putting them in a book and registering the book. But that would be one work and would be one infringement and only one statutory damage award. So the 750 limit is annoying. Sometimes it presents a little bit of an obstacle if you wanted to register all of your works. But as a practical matter, all of your works aren't available. If they're not published anywhere, if they existed only on your camera and your computer, you don't really need to register them because they can't be infringed upon. You could register them whenever you want to as an unregistered work if that's what you want. But the ones that you really need to register are the ones that you've put into, the public file. If somebody else has access to it and somebody can infringe upon it, you want to protect yourself. So against that backdrop, 750 is a workable number. And I said, a lot better than what they're doing to the video guys.
Thanks. Stanley asked that question. Stanley, do you have any follow-up to that? You'll have to unmute.
Yeah, I think the follow-up would be, and it may be Craig or anybody else here could almost speak the same thing, but with 750, with good number of people, say sports photographers, people who are shooting large events and things, there, tens of thousands of images you could have in a quarter to register. And most likely in my lifetime to actually go to court and actually sue somebody maybe one or two times. And I've been doing it for 40 years. So my question is, are there some parameters that you're advising people? Or are you saying they need to register everything? Or are you saying what type of things should be registered if you're looking at it's just cost? Because the cost you're making is not going to justify, registering everything sometimes.
Right. So if you take a sporting event and you have 1,000 images, and you make those 1,000 images available on your website, and you are contacted and you license a handful to some sports publications or newspapers, the handful that you register, that you license out, would be the ones that I'd be most concerned about registering against that large audience. In a perfect world, you register everything, but it's an imperfect world when you have that many images and you have a hard cap from the Copyright Office. So I'd focus on the ones most likely to be infringed upon.
Thank you.
Greg, can your firm handle overseas infringements, and are there any additional difficulties or issues when you take a case overseas?
You talk about international?
Yeah.
Right, so every country is pretty much signed on to, same treaties on copyright recognition and registration, but every country is different. Ours is the best country in terms of enforcement. And all we need is a US presence from that infringer, and we have them in a US court. But, the rights exist in Canada, but the recoveries aren't as good. And the rights exist in England, but you're paying reverse legal fees, and your lawyers. You're going to get frustrated internationally. Israel's pretty good. We do very well in Israel for clients. Some of the other countries, not as good, just as a practical matter. But we're still the largest marketplace, and more infringements happening here than anywhere else.
Are there any countries that you would shy away from trying to deal with?
You could make your own, without my help, you'd be able to figure out, it's unlikely that you're going to make a recovery in Honduras or Zimbabwe or even some, significant democratic countries that are not third world. Our system providing the statutory relief and attorney fees is the most generous out there. But you can do work in Canada. Like I said, Israel's pretty good. England's not horrible, not as good nearly as the US, and it just goes downhill from there.
Thank you. Before you came on, we were having a conversation about AI generated images. Would you?
I was very interested. It was amazing.
Oh, were you listening in?
Yeah, that was amazing. Those images are fantastic.
Yeah, they were. That's from our member Stan Katie. Could you talk about copyright as it applies to AI? And I guess, in general, but specifically, or can you copyright an AI generated image that you create?
According to the US Copyright Office, this is one of the few times I can give you a non-lawyer answer. No. The answer is no. Until they change the law, and I'm not really sure exactly what that change would look like. The conclusion is that any computer-generated image is authored by a computer, not by a human, and is not registerable. Even if the human puts in the original input, even if the original image was taken by a human and then altered by a computer using artificial intelligence, once you introduce artificial intelligence, it is non-registerable.
Wow.
Does that preclude you from licensing the image, however?
Not at all. Just you're licensing something that somebody could steal without any repercussions.
Right. Yeah. Okay. But you couldn't register.
100% licensable. 100% you could do an economic deal. But if somebody didn't want to license it from you, they could steal it from you, and it's not called stealing. Because what we haven't been able to figure out is who owns it. Is it the software manufacturer that wrote the AI program? Is it the computer manufacturer that generated the computer? Is it both of it? There's so many unanswerable questions at the moment that the way that the Copyright Office has chosen to deal with this is to take a total pass and just say it's not registerable. That is not going to stay forever. We are going to come up with a better understanding of what to do about this entire topic. It is the vanguard. It is where the future is. But right this second, as we sit here today, those images are non-registerable. And by non-registerable, that means that there's no enforcement available in the United States of America.
Do they have people working on that actively? At least thinking about it?
There's people talking about it. Yeah, this is a hot topic. So the Supreme Court touched upon this. Now, the Supreme Court only can interpret the laws that Congress writes, especially when we're not dealing with stuff, very political stuff where the Constitution is becoming involved. For the most part, other than these, abortion type issues, the Supreme Court is actually reading the laws that were written and trying to figure out what they say. If we sat down in the room as a group and we tried to figure out who owns something that a computer creates, we open up the Pandora's box. It's not easily closed. So it's a hot topic. There will be some discussion. Eventually, someone's going to come up with a way to describe who should be the owner. And when they do, it's going to change everything.
Is it okay if I follow up on that and ask with John Slimp's question as regards to he licensed it? Now, let's say you license it. Now you're under contract law technically, but can they just not pay and say, well, you didn't even own it to begin with?
No, you own it. And you can enforce the contract because it's a contract. The copyright has exclusive jurisdiction in the federal court system. It's the only place you can go to enforce a copyright. And the prerequisite to entry into the federal court system for a copyright claim is registration. So when it comes to a copyright claim, you wouldn't be able to enforce it because it's not registered and it's not registerable. But when it comes to a contract claim, that's in state court. You can enforce that all day long and twice on Sunday.
My understanding was you don't have to have registration. It just, nobody wants to take the case up because they can't get legal fees.
No,
Now, when did that change? Because lawyers for the MPPA and other organizations have said opposite that.
no, in order to access the federal court system, you've always needed registered work. What lawyers don't want are actual claims, untimely registered works. So you come to me with a case on a photograph that's not registered, and then I go out and register it, and any infringement from that date forward would be entitled to a statutory award and legal fees. But the case that you originally brought to me to look at, that's an actual damage case where there's no legal fee add-on, and there's no ability to ask for a statutory award. Why are those cases undesirable? Let's say that the defendant chooses to defend that case, and we go to trial, and we make a file that's this thick, and we spend thousands of hours working on it. None of those hours are recoverable. All we'd be able to get is a fee based upon whatever we would be able to recover for you, and you wouldn't be entitled to a statutory award. So unless the photograph was extremely valuable, or as I said, used as part of a product that was sold where it generated a lot of money from that infringement, the economics don't justify us bringing that case forward. It's not that we couldn't, we'd have to register it first and then we'd be able to sue on it. It's just the economics would make it untenable. But that's not a change. That's always been the case. You need to register to get into the federal court system, and it's the only place you can go to bring these cases.
Craig?
With one little caveat, there is a small claims court that they created. You still need to be registered to go there. But that is now the alternative to federal court. Doesn't really work, but it's there.
So it hasn't really proved effective yet, if at all?
The problem is it's voluntary. So if you're a defendant, you don't want to be sued, you just decline jurisdiction.
Gotcha.
And why wouldn't you?
Right.
So Stan Katie was the original poser of this question and the creator of those images that we saw earlier. And though I suspect he's curled up in a ball of tears right now, I want to give him a chance to
No,
follow up.
not really, because I knew early on that the work, you're not able to copyright the work. But images are made from thousands of other images. They're referenced, so they're derivatives. What I'm creating are derivatives of other works. There's been noise about that kind of copyright issue where these images are being taken from other images to create a new image. How, but you know, how it can be proved is up for discussion. So, there's that area that hasn't really been identified, if that makes any sense.
Well, right this second, and this is as of March 16th of this year. Let's see. In the office's view, it is well established that copyright can only protect material that is the product of human creativity. Most fundamentally, the term author, which is used in both the U.S. Constitution and the Copyright Act, excludes non-humans. The office's registration policies and regulations reflect statutory and judicial guidance on this issue. Okay, so if a work's traditional elements of authorship were produced by a machine, the work lacks human authorship and the office will not register it. That is the current position of the U.S. Copyright Office.
But the same could be said for people who create images using Photoshop. Take a blank
because Photoshop won't work off a prompt. Photoshop is a tool in the hands of a human. So is a camera. We don't make you sit out there with an easel and paint it anymore. The camera is a tool, but you are the human guiding and using that camera, so it's a work of human authorship. But the computer that works just off a prompt and composes a song or writes a Shakespearean play or makes Picasso, that's not a human doing it, that's a machine doing it. And right now, until we figure out a better answer, the answer is that it's not registerable.
So what if you misrepresented an AI created image on a registration and submitted it, and then later found out it was AI generated? Are you subject to criminal prosecution at that point, or what happens then?
I don't think it would rise to the level of criminal. I don't think the submission to the Copyright Office is under penalties of perjury, but it would be, voidable.
Mm-hmm.
Yeah.
If you tried to enforce it and you testified that you created that image and it came out later that you were lying, that is perjury. So there are consequences. If you take an example of an AI created image registered, we seek enforcement. It doesn't go to court. It doesn't involve testimony. Could it fly under the radar? Probably, because those images that Stan was showing us are hard to recognize as being generated by a computer.
Look pretty great.
Look pretty great to me.
John's just asking for a friend.
No, well, I just say I haven't even played with it yet, so I have no idea. But I was just kind of curious.
Greg, can you talk a little bit about fair use, or is that too big of a discussion for the amount of time we have left? People are always claiming that they have the right to use our images because of fair use.
I could touch on it. I can't really get into it because we could spend the whole night on it. It is the defense you hear most frequently because it is the only defense to a copyright infringement. At the end of the day, when we've gone through the analysis, we know it's not posted by a user, so we've taken out DMCA. We know it's not an embed, or it's in an embed friendly location. What we're left with is what I would call a prima facie copyright violation, which means we've checked all the boxes and we've proven before we even file the case it is an infringement. So you're the defense attorney, you get this case, or it's pre-filing, you get a letter. What is your response? Well, your response is an argument. It's fair use. What does that mean? Well, technically it means that the use is considered beneficial to the Copyright Act. So we should not discourage it, but we should encourage it, because what we've created is a new work from a pre-existing work that's separate and apart and distinct. we've transformed, and that's the word you'll hear most frequently, the original work into something new and something that we should cherish and enjoy and we should encourage.
I have a question.
What I'd like to do with this one, you know what? I don't know if anybody here followed the Andy Warhol case. Any Andy Warhol followers?
Yeah.
We're about a month away from the Supreme Court rewriting the entire discussion on fair use. Andy Warhol case is a very interesting case. I will, while I'm talking to you, I will try to find the Andy Warhol Prince images and push them up on the screen.
Is that Lynn Goldsmith?
Yeah,
Yeah.
I think so, yeah. Mhm.
So
She's an ASMP member too.
here, this is, it's not the best one, but it's, at least I found something quickly. Did I share anything useful here? Or I share my whole screen?
That's good.
So the original photograph is on the right. I don't see the Warhol. It is over here. That's not exactly what it looks like on the left.
What about down in the middle center there?
Yeah.
Bottom
The
center.
case was brought by the photographer against the Andy Warhol Foundation in Southern District of New York. And the district court judge dismissed the case on a finding of fair use. The Second Circuit, which was a very surprising decision, reversed and reinstated the case, finding that the use was not fair. The Supreme Court decided to take this case up and hear it. And if you listened in on the oral argument, there was a very extensive discussion, which I'm hoping becomes part of the new analysis. And the discussion was the original photograph essential to the creation of the new work? And what was focused on by the court in this discussion was it this particular photograph that was essential, or could they have used any photograph? And if the answer is you could have used any photograph and Andy Warhol any photograph, then this would not constitute fair use because the work was not essential. That's not currently the test, but it may be, and we're going to know in a month. Right now, what you'll find is that this discussion changes depending upon your audience, because you're asking a judge to decide a 4-part test. Part 1 is the work transformative, which is a question that's difficult to answer under the best of circumstances. Is it a new work or is it an adaptation? Because remember, you're entitled to your own derivatives. Is it used for commercial purposes? That's part of it. If it's used for educational purposes, it may be more transformative than if it's not. The second test element is the use in character and purpose. The third is the percentage of the work used. The fourth is the impact of the commercial marketplace. If we allow this use to be done by anybody similarly situated, have we destroyed the commercial marketplace for that work? And this comes up if, you know, we're moving from one media to a different media. Was that, you know, bridge the gap situation? Was that a reasonable adaptation? You'd have that with screenplays, going to movies and books to movies. But what we're really talking about with photography is news reporting. That's where this comes up the most. Somebody wants to write a story, they see your photograph, they need artwork to accompany the story. They put the photograph in with their own story and they say it's fairly used. Most of the time, we're able to push back on that because it's just not the case. It's eye candy. It's not essential to tell the story they want to tell. It's essential to sell the story that they want to tell. And therein lies the big difference. So that's why I'm very keyed up and looking for this SCOTUS opinion, because if the word essential appears in that decision, then I probably would win on this issue 99 out of 100 times. Right now, the way it plays out depends on where we are, what court we're in front of. I'm pretty accurate at predicting the court's temperament on this issue, but it's pretty hard to give you one rule that fits all situations.
So Craig, I'm kind of confused as to why that is, how one court, you know, in California can rule one way on the same question where it's ruled differently in another court. I mean, it's all federal law, so I'm kind of confused there as why it's not covered under, you know, a national standard.
Well, I'll give you one more. So we have 11 circuits in this country, 11 circuit courts representing geographic areas,
Right.
plus the federal circuit. 9th Circuit covers, like I said, just about the whole left side of the country, largest population by far. 2nd Circuit covers New York, Connecticut, Puerto Rico. 3rd Circuit covers Jersey, Pennsylvania. But then when you get to the 9th Circuit, you're talking about Arizona, California, Washington, or the whole left side. And each court in each state, in each, you know, California's got 4 districts. All the courts in that, like we'll take the Central District of California, for example, that's Los Angeles. Those are all considered sister courts. All those judges are on the same level. The only people those judges need to listen to are the circuit court above them or the Supreme Court above the circuit court. So if there's no Supreme Court authority and there's no circuit court authority, they could all decide whatever the hell they want.
Huh.
Right? They're all looking at the same statute, or they're all looking at the same fact pattern, but they're interpreting it differently. Now, we do have a very strong stare decisis. We do have a system where once a court has spoken, a higher court, all the courts beneath it need to apply that same test and those same rules. So when I gave you the situation with the embed, the 9th Circuit has a decision, like I said, using the server test. They're the only circuit to have decided this issue. There isn't a circuit court split. So the Supreme Court won't get involved until it becomes an issue where 2 different circuits are deciding things differently.
Okay.
And nobody's brought this up at the circuit level in any other court. So right now, you have one circuit that's spoken to this issue, and you have a whole bunch of district courts outside of that circuit that have come up with different analysis and different rules. And until this gets reconciled at some point in the future, it's depends on where you're located.
Well, thank you, Craig. I want to be conscious of your time, and we're really appreciate you spending the last hour with us. Do you have any bit of wrap up you want to do? And let me introduce Donna to you guys. Donna is kind of our go-to person for arranging this, and Donna, we're appreciative of all your hard work and helping arrange this.
Thank you. Pleasure being here this evening. I hope everyone has learned a little something this evening that you didn't know before. And we're here for you all the time.
One more quick question, Craig. Do you there's talk of a possible documentary coming out of the book that I did. Do you guys handle those kind of contracts and so on?
Sure. I mean, anything involving intellectual property, our office handles. So we'd be able to help you with that.
Okay, cool. All right, super. Thank you. Thanks very much. This has been quite informative and a lovely discussion. I appreciate your time. Both.
No problem. Thank you very much for having me.
Yeah. And
Thanks,
thank
everybody.
you, Michael, for setting this up as well.
You bet. Good night, everyone.
Good night, everyone.
Good
Night.
night.